Now, we're on item number 13, and Mr. Vice Chair Wishnia has recused himself, as I understand. Is that correct on the record? I have. And as Chair, I am recusing myself as well. Therefore, we will now defer to former Chair. Former Chair Cobbins will now take the gavel. Thank you.
Well, can I just listen? I just like to hear it. Yeah, I think that's a good idea.
Item number 13 relates to the consideration of the board's authority and management's request that the board reject the arbitrator's award in the Belinda McIntyre grievance case and the taking of such action related to the matter as the board deems appropriate. There have been some questions as to whether the board should be taking the issue up or not. For this particular point in the process, we discussed allowing representatives from management and from legal representatives from management and from the union to articulate their position one way or the other as to the merits of this coming before the board, and then the board taking that in consideration and ultimately arriving at a conclusion as to what steps we take next going forward. So, anything I need to add?
I was going to say, the only thing I wasn't aware of was it was just legal representatives that both the union and management may split up their presentation.
Both the union and management. It may go beyond just legal.
I was going to say, he said legal representation for both parties who would present their positions. And I said, we hadn't talked about limiting it to legal. Both the union and management may wish to have someone else speak to the issue today as well.
Okay.
Mr. Chairman, may I address you? I'm
Sure.
Deborah Godwin. I represent IBEW Local 1288 and Ms. McIntyre here today. And I noticed that there's a court reporter, and I'm not sure of the reason for the court reporter, but my understanding was, as you indicated, that this was to be a legal argument only, not presenting some sort of witnesses. And what I see appears to be the intention of management to present witnesses of some kind.
If I may, Mr. Chairman.
Yes.
Jeff Weintraub for the division. We're presenting no witnesses today. I agree with Ms. Godwin. That has to be done if there is going to be a second meeting.
Commissioner Evans.
Chair Cobbins, I thought at this point we would also be just discussing whether or not we should be hearing this and whether or not we, within our authority as a board, we've never relinquished our responsibility as board members to carry on the work of the utility from a governance standpoint. We identified a process, it appears, through the memorandum of understanding, which outlines a grievance procedure, which includes an arbitration step. And the question to me is whether or not we would like to supersede the actions of a qualified arbitrator usually selected. To me, that's the question before us.
All right. Well, we'll, I guess you can get one of the parties to state their position.
Yeah, I think management should start off and have the union make their presentations after, if that's acceptable to everybody.
Is that agreeable to that management start off with their position first? Or do we need to flip a coin? How do we do it?
You know, I just would like to know what management intends, because I see a lot of people over there, and if it's just Mr. Weintraub who's going to be presenting the position of the division, I have no problem with that, but if he's intending to present all these individuals before I get a chance to speak, I would tend to object to that. I do have a short written argument that I would like to provide the board members as well.
I guess
Excuse me. Commissioner.
Go ahead, sir.
No, we're not planning on presenting any witnesses today. Mr. Collins is going to make a brief statement. Then I will present the legal position. And then we have to wait to see what Ms. Godwin says for anything else. But we're not planning on any witnesses on the merits, anything like that. That would only be if there is going to be a second meeting.
I would like to hear management came to us and said they wanted us to hear this because they wanted to appeal the decision of the arbitrator. I would be interested in hearing why management feels we should consider hearing this. We know that we have the authority to hear if we wanted to, but I'm trying to understand just a brief statement from management as to why the board should entertain this.
So on that basis, we'll have management start out with the basis for bringing this to the board, and once they've approved it, we'll follow up with
And may I ask, are your microphones working?
Yes.
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 Because they can't hear you back in the back of the room.
Okay, we'll just lean in.
And I'm going to get things started and turn it over to Jeff Weintraub in just a minute, okay? Just bear with us if you don't mind. When it comes to matters of grievances and discipline, the MOGW board functions as the final authority. During my tenure here at MOGW, there's been some occasions wherein employees have bypassed the grievance and arbitration process and brought their grievance directly to the board. In past times, other MOGW boards have heard appeals following an arbitrator's decision. Arbitrations don't happen very often, only about 50 times in the last 40 years. And appeals to the MOGW board following arbitration has only happened twice in the last 40 years. By hearing this case, are you setting a precedent? No. You're just doing the job that the board was intended to do. Why is management seeking to appeal this particular case to the board? Well, I'll tell you. This case involves a credit counselor and two Hispanic customers, a mother and a daughter, and the daughter is about 14 years of age. The mother does not speak English, the daughter does, and therefore that 14-year-old daughter was heavily involved in the transaction that took place. On the day in which the incident occurred, several questions are raised.
Excuse me. It seems to me, Mr. President, that you're getting into some of the particulars of the case. I guess my question about the management's basis would be hearing just the legal reason this board should go beyond the arbitration process. I don't want us to get, the reason I asked for separation of this hearing from hearing the case was to not hear the particulars of the case, but just on the merits of process and procedure. Was there anything that took place during the arbitration process that would cause us to need to hear
Yes.
the item without hearing the specifics related to the case? If you could do
Yes.
that, I think it would be better. Thank you.
There's been a long-standing practice that I was not aware of, wherein during arbitration cases, MOGW has historically not brought in witnesses, victims, or customers for the purpose of testifying. When this arbitration case was heard, the mother and her daughter were not brought in to testify out of consideration for them as customers. Now that the arbitrator has made a decision without having the benefit of having heard the testimony of those two witnesses, we feel like that decision not to bring in those witnesses at that point was probably the wrong decision. And this is a case of public trust and a case of making sure that we do everything that we possibly can to make sure that customers aren't taken advantage of. And I feel like that if we're going to do the right thing and maintain the proper level of public trust, that the testimony of every witness ought to be heard and all facts ought to be brought forward to the case so that the board can then make a decision as to whether or not the arbitrator's decision should stand or not.
Yes, ma'am.
Just two follow-up questions. Who made the decision not to bring the witnesses?
Human resources.
Okay, so did the arbitrator prohibit your bringing witnesses?
No.
Was the arbitrator selected in the process outlined in step 4 of Article 12 of the MOU?
You would have to ask that to someone in the human resources department.
Which that section basically outlines the grievance process, with step 4 being the process for selecting an arbitrator if the case is decided to go to arbitration. So was that selection made in accordance with that article?
Thank you. Can Jeff answer that?
The memorandum was followed.
Okay, thank you. And then one final question. You mentioned that there have been times where employees have bypassed the arbitration process or the grievance process and appealed directly to the board. When an employee did that, were they, if they did not like the decision of the board, could they then go back to the arbitration process?
The board is the highest level of decision making. It's like the Supreme Court, so to speak.
Thank you. I mean, that was the answer I expected you to give me. I just wanted to be certain that you would give me that answer. Thank you.
I want to turn it over to Jeff Weintraub.
Thank you, Mr. Collins. Commissioners, I'm Jeff Weintraub. I am the managing partner of the Weintraub firm, which is a partner in Fisher & Phillips. Our firm has had the honor of representing the division for, well, since the 60s. And I personally have been involved in representing the division in many cases for 25, 28 years, something like that. Initially, I'd like to pass out some outlines of just some points I'm going to raise. And Commissioner Evans, if I may, you're exactly correct in what you said. The memorandum procedure was followed in this case. But as I will address in a few minutes, the memorandum procedure includes the right of the Board of Commissioners to approve and reject arbitration awards in the best interest of the division and its regulators. But I will address it.
Point well taken, and I agree with you. I agree.
First, Commissioners, in trying to clarify the enforcement issues and so forth, I would point out something you already know. The board has the power and the authority to ensure the best interest of MLGW and the public is served, and in this case by rejecting the decision of the arbitrator in this particular case. This is a case where the integrity of the division and MLGW's commitment to treat all customers ethically, regardless of whether they speak English, is on the line. And I'm not going to go into the specifics. I think Mr. Collins has covered that, but it's the division's position that in this case, the grievant engaged in some inappropriate activities and took advantage of a non-English speaking customer with regard to money and ended up almost succeeding in taking over $100 from the customer. Now, that will be addressed in the merits, and not today. That's just the background. Moving beyond the specific points at issue here, Commissioners, or the merits of what's at issue here, the only, as Mr. Collins said, there were actually only two first-hand witnesses to what happened. One of the first-hand witnesses was the grievant. She was there. She testified that she didn't do it. The other first-hand witnesses were not there. and that is the customer, just reiterating what Mr. Collins said. Very briefly.
I think Mr. Weintraub, you are telling us again specifics of the situation as opposed to focusing on management's of the board's authority to hear an appeal by management from an arbitrator's
Yes,
decision.
ma'am, I'll move on. I'm simply reiterating why this is different than the ordinary case. We're not here because we lost an arbitration.
Okay, it's different, and how do you, if you can explain the difference in more general terms, I think it would be more appropriate.
More general terms as to that point,
As in,
What makes this unique?
thank you.
well, the uniqueness, frankly, is the fact that, as Mr. Collins has stated, there's a matter of the division's integrity, trust with its customers, and especially the non-English speaking portion of its customers, and the fact that in this case, in an effort, this practice that the division has followed since the days of Mr. McClure was labor relations manager, was a practice that was designed for one thing and one thing only, and it's the same reason we're here today, and that is to protect the customers. The practice was the customers were not brought into the arbitration hearings to miss work, have to take time off, be sworn, go through a hearing, and be subjected to direct examination and cross-examination then by the union attorney. It was felt that that's not something we should do to the customers. That is a practice, by the way, Commissioner, that because of this case, the division now looks at differently. And we are going to, on a case-by-case basis, consider using customers in the future. We have no choice. And again, and not to burden the point, but you only had the two sets of eyewitnesses. And once the second group of eyewitnesses, that is the two victimized customers, did not appear at the decision of management, once they didn't appear, that meant there was one first-hand eyewitness, and that was the grieving. And if you have one side, any fact finders, if you have one side that says the light was red, I saw it, and it was red, and the other side says, well, I heard it was green. We all know what's going to happen. The result is the fact finder is going to decide the light was red. We're not come here to complain about Arbitrator Clark's decision. We're here because Arbitrator Clark didn't get to hear the witnesses, the other side of the coin, the first-hand eyewitness direct witnesses that we propose to bring before this board in its second meeting. Now, moving on from there.
Excuse me, Mr. Weintraub.
Yes, ma'am.
I hear you're saying that the witnesses were not, the arbitrator did not hear the witnesses, but the arbitrator, from what President Collins said, did not prohibit the witnesses being heard. And management chose not to, even though management knew that the other side brought witnesses, I'm assuming.
You're absolutely correct, Commissioner. We knew going in that there was going to be a problem. We wanted to use the customers, but the practice effectively prohibited that. If you're asking me,
Did the practice prohibit it?
The effect of the practice was that we were prohibited from doing it because we could not bring customers in because of the desire to protect the witnesses. It's something we truly wanted to do. We knew what we were up against. Our hope, Commissioner, was that the video disc would be sufficient, but in this case they weren't because Mr. Clark excluded them. So at that point, we weren't left with much.
Commissioner Masson, you had a question?
Did any kind of Arbitrator Clark request or make any kind of question regarding witnesses?
He did. There were comments that I believe are in the record. I couldn't quote it to you exactly, but he did note in his decision that in his decision he was not finding that the grievance did not attempt to steal that money of the Marquezes. He said that she had first-hand direct testimony, and we didn't. Our evidence, our testimony, our hearsay testimony was insufficient to overcome the direct first-hand witness. We're back to the red light, green light. And I don't want to spend too much time on that issue, but that's why we're here. Had we brought the Marquezes, and for some reason the arbitrator still ruled against us, we would not be here. Ms. Godwin has told me before, she said, hey, you had an arbitration, you ought to take your lumps and go home. We don't disagree with that viewpoint in the normal circumstances. This is not the ordinary case, and that's why we're here. Now, if I may proceed a little bit to the authority of the board. As Commissioner, as you've stated, the board does have the authority here. The board, in the way it's created and the way it acts, is accountable to the electorate. This is the reason, for example, that Memphis Light, Gas, and Water is not under the federal statute, the National Labor Relations Act, because there is no coverage, because you are a public sector utility that is in fact accountable to the electorate. A third-party arbitrator is not accountable to the electorate, and this is part of the basis for the reason that arbitrator decisions are not enforceable in the public sector in Tennessee. The board ultimately is the final arbiter, as I've heard Mr. Collins say from time to time. There's a concern here that the union has raised. I don't say it's an illegitimate concern, it's a legitimate concern. Isn't this going to open the floodgates? No, ma'am, in my opinion, it will not. Mr. Collins can address that better than me, but I know that there's no intention here to routinely ask the board to overturn or reject an arbitration decision it doesn't like. Commissioners, in 40 years, it's happened twice. The last time was approximately 1978. That's the only time that management felt strongly enough about something to bring it to the attention of the board, and that's what I'll be addressing in a few minutes. So there is no danger of a floodgates argument here. This is an extraordinary case. This board, Commissioners, does have the exclusive authority to be accountable to the electorate, to reject an arbitrator's award. It has the authority to manage the division, as you know, and this broad authority, as I'm sure you're all aware, comes from, in many places, it comes from the City of Memphis Charter. It's going to be traced all the way back, and it may have Exhibit 1. This goes all the way back to 1939, and actually before that. The Charter provides that all utility systems shall be under the jurisdiction, control, and management of the Memphis Light, Gas, and Water Division. And in your materials, that's Article 65, Section 666, and I believe we have it marked. Further, the board power granted by the Charter is designed to ensure that the board has the authority to do what is necessary to the benefit of MLGW and its ratepayers. The City of Memphis Charter provides that, quote, the powers hereby granted shall be liberally construed to effectuate the purposes hereof, and to this end, the Memphis Light, Gas, and Water Commissioners shall have power to do all things necessary or convenient to carry out the purposes hereof, and that is Exhibit 2. You could pass that out, Mr. Day. Article 65, Section 699. Commissioners, the board's broad authority includes the power to reject or not reject the decision of the arbitrator in this case. And if I may point out, the board has already uses that authority because every arbitration award is submitted to this board. You may not address it, you may not talk about it, you may not actively make a decision, but you have the authority to do so because you can approve it or reject it. Every single arbitration, Mr. Collins says something like 50, y'all have that authority and that right to do so, and it is before you. It would in fact, Commissioner, be a violation of your legislatively granted power for the board to assign that exclusive authority to a third-party arbitrator who is not accountable to the elected. So now I want to give you, I don't want to get heavily involved in cases, but I am going to hand out a few cases. Lawyers do that, Commissioner, so you have to forgive me. I'll do that in a moment. Question?
Yeah, just one quick question before we get too far removed from the statement you made earlier.
Yes, ma'am.
And when you mentioned that the DVD was not admitted by the arbitrator, did management have an opportunity to present witnesses subsequent to the arbitrator's issuance of the interim ruling not to allow the DVD?
On the subject of witnesses about what? About what was in the DVDs?
Yes. You made a statement that after the DVDs were not allowed, you didn't have very much left.
Didn't have much left.
And I'm asking, that ruling regarding the DVD was presented as an interim ruling prior to the arbitrator's final ruling?
Yes, it was further after that, further witnesses after that.
Did you have an opportunity to present witnesses after that decision?
We did. We had that opportunity.
And chose not to?
Correct. We
Because of
chose
your
not.
longstanding, the utilities'
Because of the
longstanding
long-standing
practice?
practice and desire, not just because it's a practice, Commissioner Evans, out of a desire to protect the customers, protect the Marqueses. They had already, in management's view, been victimized. We did not want to subject them to that again. That was considered. As a lawyer, did I want to use those witnesses? Absolutely.
Okay,
But
thank
the,
you.
but the protection of the customers came before my wishes. That's the bottom line on that. The authority of the board, as I said, is exclusive, and I want to just mention a couple cases to you that I'm going to give you in a few moments. One is Local Union 760 of the IBEW versus the City of Harriman. It's a 2000 Tennessee Court of Appeals case in which the court in that case said that public sector employers do not have the authority to enter into collective bargaining agreements. That's why we call them memorandums of understanding as opposed to contracts. They're not contracts. The same reasoning was reached in federal courts applying Tennessee law, the Kramer v. Luttrow case, and I'll give you that in a moment too. Allowing a third-party arbitrator who is not accountable to the electorate to have the final decision in a matter of management is not permissible under the powers granted by the City of Memphis Charter. Continuing, Commissioners, the board's authority specifically is recognized in the Memorandum of Understanding. And if you would pass out Exhibit 3, Mr. Day. Again, I'll give you a couple of copies of the various memoranda from 1970 up through the current memorandum, the one that's in effect 2010 through 2014. But you'll have before you specific provisions in all of the memoranda. And I'm going to quote to you from Article 7. It's actually Article 7 in the current memorandum, which I will read to you, just a brief paragraph. Quote, under division responsibility, Article 7 in the current memorandum, which is on the last page of the materials. It is understood that nothing herein shall require the board to do anything forbidden by or refrain from doing anything permitted to be done by applicable law. Nothing in this memorandum of understanding shall be interpreted as abrogating the authority vested in the board for the exclusive management, control, and operation of the division. And to management, what that means, Commissioners, is that there's nothing in that memorandum or outside of it that takes away your authority. The local can't do it, and management can't do it. You have the authority, and y'all can't get rid of it. It's your burden. The board's authority extends to the review, approval, rejection of arbitrator awards, and that is evident by the fact that in the past, twice, this board has rejected arbitrator awards. The first one, the most recent one I should say, was in 1978, approximately. An arbitrator ruled that management did not have the right to decide which employees could work out of class such that they could become candidates for supervisor positions. Management went to the board on that. Why? If there was no problem, Commissioners, with the following of the procedure. The procedures were followed there. Everything was done exactly as in this case. There's no complaint about something was misapplied or done wrong in the particular detailed procedures of the memorandum or its grievance and arbitration procedure. Same in the 1978 case. Management went to the board at that time because of the important interest in management being able to select its own candidates for supervisor positions. The board exercised its authority in the best interest of the division and the ratepayers. And that was an important case, as is this one. In an earlier situation, in approximately 1970, perhaps 1971, the board, on its own initiative, the board did this, not the local, not management. The board rejected an arbitrator's decision because it determined that it was in the best interest of MLGW, the ratepayers, and the electorate to reject a decision where an arbitrator had denied African American employees who I believe were acting as porters, working as porters, to deny them equal 1 hour lunch periods to the other employees. They only had 30-minute periods, and the arbitrator upheld that. The board acted on its own initiative to rectify what it saw as an incorrect result because it was important. That was an issue of trust. this case is an issue of trust as well. I need to point out, Commissioners, that nothing in the memorandum takes away from that authority. We talked about the authority of the board. Nothing in the memorandum takes away from that authority. And if I may, if you would pass on Exhibit 4. It is clear, as I just read, Commissioners, that the memorandum does not and is not intended to abrogate the board's authority. But the MOU from 1970 until the current day, included in the current contract, has provided the following. And again, I'll read that from the actual current memorandum, which is your last page there. And this is it's the third paragraph in step 4 of the grievance and arbitration procedure. Quote, "It is the intent of the parties to preserve such rights of appeal as employees may have possessed prior to the effective date of this memorandum of understanding. And it is not the intent of the parties through this grievance and arbitration procedure to diminish the authority vested in the board. The union cannot deny that there were 2 times that the board acted to reject an arbitration award in the past, at least 2 times. This language says that authority has not been diminished. Therefore, it still exists as much as it did in the 70s and the 80s and after that. There is no language in the MOU that takes away any of your authority to act under those circumstances. Nothing. But there is language, as I've told you, that tells you that, so it doesn't give it to you, it acknowledges that authority. The local asserts, without any affirmative statements in the memorandum of understanding, that the board no longer has the authority to review employee grievances. At least that's what I saw in one of the emails that was sent a few weeks ago to the board. Put simply, the union cannot deny that the board has in fact acted in this way twice to reject arbitrator decisions when it thought it was important, when there was transcendent significance, something beyond just the effect of that case. So the board still possesses that authority. Having been in labor relations for 30 years, I know, dealing with hundreds and hundreds of contracts, that if such a drastic truncation of the board's authority were intended, assuming for a moment that the union and management could even do this, which they can't, that such an act would not, if they were going to take away your authority, it certainly would have been expressed very clearly and unequivocally in the MOU, and it is not. The board's authority to hear employee grievances is also well established. I believe you're all aware that there are 2 ways an employee's grievance can be invoked with the board. One, either the local or the division can approach the board with a grievance that has made it through the arbitration stage. Or 2, an employee can bring a grievance directly to the board without going through the grievance and arbitration process. If he chooses the latter, then he waives the grievance procedure because, again, the board is the final arbiter. As I've heard Mr. Collins say before, what would happen if it was not? If you allowed the employee to have decisions that whatever one he liked, he could take to the board. And the employee can't do that. In this case, because it's of transcendent significance, this is what we're asking the board to do, is to take a look at the merits of this case. And that's all we're asking for at this point, Commissioners, is the opportunity to have this second meeting so that you can hear all of the evidence. We're not asking to rehear all the previous witnesses. We don't think they should testify. All we're asking to do is to bring the new witnesses, specifically Ms. Marquez and her daughter, to hear what the arbitrator did not hear. My own opinion, which doesn't mean anything here, is that had Mr. Clark heard the Marquezes, this arbitration would have gone to management hands down. It's just my opinion, but that's what I believe in this particular case. And I might point out, Commissioners, I'm sure you're aware of this, but there have been many past and recent situations where employees have come to the board. In 2004, employee Ricky Rogers, I'm not going to use those exhibits, I think is well known, elected to go to the board, waived his grievance hearing over an indefinite suspension. In 2009, employees Sandra Benson and Peggy Evans chose for the board to rule on their grievances. I assume y'all are aware of those cases. If not, I have some paper. Okay. Now let's get to some of the cases that I promised. The delegation of authority, board authority to a third-party arbitrator can't do it in Tennessee, as the MOU is not enforceable. Tennessee case law supports this, and this is really the thing that mostly counts here, Commissioners, and I'm going to mention to you again, if I may see the cases, the IBEW versus City of Harriman case, the 2000 East Tennessee Court of Appeals, Tennessee case, makes it clear that the Tennessee Utility Company's memorandum with IBEW, in that case, not only was unenforceable, but actually was void. That's the ruling of the court. Another Tennessee court, in the Simmerly case, which you also are being passed out, commented this. They noted that the Tennessee legislature has created a structured statutory framework to govern collective bargaining in the realms of education and transportation. That is known as enabling legislation. That's why the teachers can bargain and the bus drivers can bargain. So the court found that, and this is an interesting quote, the legislative silence on this issue in the electric plant law equates to the General Assembly's desire to prohibit collective bargaining in the public utility sector. That is a Simmerly case. I believe it's page 39 of that case and should be marked. The Sixth Circuit, which covers Tennessee, the Sixth Circuit Court of Appeals, in Kramer v. Luttrell, which is cited in Simmerly, said, quote, the Tennessee Supreme Court would continue to hold that contracts between municipalities and labor organizations are unenforceable under Tennessee law. Tennessee law has been clear on this point, Commissioners, for decades. It started, and again, that's why they call these memorandums of understanding and not contracts, because they're not enforceable. It started in 1957 in a Tennessee Court of Appeals decision, the Weekly case, which we're also passing out to you. In that case, the Tennessee Supreme Court, the Tennessee Court of Appeals stated that a municipality cannot enter into an enforceable collective bargaining agreement with its employees. Thereafter, the Tennessee Supreme Court, in the Keeble case, which we're also passing out to you, held that the Weekly decision accurately reflected Tennessee's public policy. A federal court in Memphis, in my opinion, would reach exactly the same conclusion. I want to mention a couple of MLGW cases to you. In a case some 30 years ago, Judge Julia Gibbons, who is now on the Sixth Circuit Court of Appeals, stated that it appeared that the MLGW Memorandum of Understanding, quote, may not in fact be an enforceable contract under Tennessee law, close quote. She said it even though she didn't have to decide that point in the case. It was what we call dicta. But she didn't have to say it, but she said it. The second case was a case I tried on behalf of the division in 1986. My party representative at that time, Larry Papazan. This was tried before the late Judge Horton. This is the Jones v. MLGW case, sometimes known as the priority posting case. In this case, Ms. Godwin, Lynn Agee, and Rich Fields had filed suit against MLGW challenging the affirmative action plan of the division, which we called at that time priority posting. One of their arguments was that the division's affirmative action plan had to be struck down as it violated the seniority rules in the memorandum. We won that case, and Judge Horton
Before we start, thank you so much for a moment. It appears that what we've heard so far is management would like us to hear this. We know we have the authority, the ability to hear it. There's no question we have the ability to hear it. Management wants us to hear it primarily because the outcome is not what they expected based upon their failing to call witnesses.
Decision to not call.
Yeah, their decision to not call witnesses
That's a
is something,
justification.
is a thing that they want to do differently. It's not that there was a problem with the arbitration itself, but with management's decision on how it handled its defense of the arbitration, of the grievance.
I don't speak for them, but that's how I understand it to be the case.
Is that basically it? The appeal is to present witnesses that were not presented during the arbitration process.
And quite frankly, not all of the facts were presented in the arbitration
So there's some other
therefore-
facts that
Well, obviously, the fact presented by the witnesses that did not testify
yes,
never was considered.
yes.
And so all the facts were not available to the arbitrator. And as a result of that, we have a situation where, in my mind, the best interest of the customers was not carried out. And that's where we need to end up.
Okay, and in your indication that all the facts had not been presented, management had the ability and the opportunity to present those facts, and it chose not to.
And we have the same ability and opportunity
Here,
for the board.
if we allow
The board
it.
can choose not to, or to hear.
So if at any time in the future, back to your point, Commissioner Coggins, if either side were to second guess or look back after the fact and say, oh, the outcome might have been different had I handled my defense of this differently, then, well, let's take it now to the board. And I'm just concerned about us wanting to get involved in that. Just thank you very much for summarizing why management wants this to be.
Yes, I have a brief memorandum which sets forth the union and Ms. McIntyre's position in this matter with regard to why we believe that the arbitrator's award should be enforced by the division management and why you should not, quote, hear this matter. And I'm going to deviate from my paper for just a minute to say this. We've used the term hear this matter in a sort of generic fashion, but I would ask you, if you decide that you have the authority to consider this matter, that what exactly are you hearing? Now, in the past, in 1978, I would submit to you what was heard at that time was the reward went to the board, and the language in the MOU was different at that time, and I'll get back to that in a minute. Clearly, back then, the decisions were advisory to the board. The arbitrator's awards were, let me give you that language right now. It said, the arbitrator's decision shall be in writing and shall be advisory to the Board of Commissioners of the division to assist it in making a determination. That was the language that was in the memorandums of understanding until 1980. Okay? Now, after 1980, that advisory language was negotiated out of the agreement. It is no longer in the agreement and has not been there since 1980. The language now simply reads, the arbitrator's decision shall be in writing to the parties. It doesn't say that it's advisory to the board.
To be in writing to the
Parties, to the parties. Okay. So back in 1978, and Mr. Weintraub discussed the decision about working out a class, what was at issue there is when an arbitrator acts outside his or her authority, under any contract that sets forth a dispute resolution procedure, the arbitrator must act within their authority under the contract. And there's no doubt that the arbitrator under our MOU here has to act within the authority of the contract. And the language specifically does state, and has been in all the MOUs, that the arbitrator's jurisdiction shall be limited to questions, grievances, and disputes involving the working conditions or interpretation, application, or performance of specific provisions of this memorandum of understanding. He shall have no authority to set policy or to add to, subtract from, or change any terms of this memorandum of understanding. The parties recognize the need to resolve grievances as soon as possible and must fully cooperate in this endeavor. So, the circumstances in which the board, back prior to 1980, and which I would submit to you, the board may certainly have the responsibility now and perhaps in the future, is if an arbitrator acts outside the scope of his or her authority, and attempts to set policy for this board, then that arbitrator would be acting outside the scope of their authority, and it would be the board's responsibility to act, to consider that decision. But I would say to you that under no circumstances does this board have the authority or jurisdiction to conduct some sort of a supplemental evidentiary hearing in a discharge case. And what you would be doing here, I mean, if you think about it, is if Mr. Weintraub were to get his way, or the administration were to get his way here, and they can bring in one witness that wasn't heard, they chose by their own choice, by their own strategy, not to present in the arbitration, and they can present that witness to you, then what has happened to Ms. McIntyre's due process? What has happened to her ability to confront her accusers, to cross-examine her accusers, to present her evidence? Are you to hear one witness out of the context of the entire hearing? I mean, that makes no sense. How can you make a decision based on one witness? So, you're not a civil service board. You know, if you're an employee of the city of Memphis, you have the right, as Mr. Masson knows from being the CFO, and Mr. Brigham was the chairman of the civil service board. Employees of the city of Memphis have a choice of going to a civil service hearing to challenge their discharge, or if they're represented by a union, they can go through a grievance and arbitration process. And that's their due process. Because they're a public employee and they have the right not to be fired except for just cause, they have the right to confront their accusers, to present evidence on their behalf, to examine and cross-examine witnesses. Now, we don't have at MLGW, the employees have one choice. They have grievance and arbitration. Now, perhaps they could come to the board with a grievance, but if they do, they waive their rights under the MOU to go through grievance and arbitration. So we went through that process. The arbitrator was chosen by the parties through a mutual selection process. He is one of the foremost arbitrators in the country. He arbitrates baseball disputes. He's a prolific arbitrator. I think Mr. Weintraub would agree with me. Each party had the opportunity to present all the evidence. The division called 7 witnesses over 2 separate days. The first day was in January 26th of 2011. We continued the hearing at that point because MLGW said we might have these videotapes. We might have maintained them. So the hearing was continued. They had then until May 4th, I believe. They had wanted at that point to call the Marquezes. They could have, they should have. Frankly, I wondered why they didn't. But had they, I would have had the opportunity on behalf of Ms. McIntyre and the union to cross-examine those witnesses. But what they're contemplating here today, or a few weeks ago, was bringing the Marquezes in here and doing what? I don't exactly know, because there's no procedure for this type of thing. But I believe it was to have this board question the Marquezes. Now, I would submit to you that if you proceeded in that fashion, one, you are opening a can of worms, but you're also violating the due process of Ms. McIntyre, because her good name is being called into question here. And as such, she has a right to defend herself. And this is a public forum. They're attacking her good name in a public forum, and she has a right to defend herself. So would you have the whole hearing all over again? Would you hear little pieces of it? I would submit to you that if you have authority or jurisdiction, it's to read the decision, to ask, did the arbitrator exceed his authority under any provision of the MOU? And if not, and you've heard Mr. Weintraub, he's admitted the procedure was in accordance with the MOU. There's nothing wrong with the decision. It's just basically they made the wrong strategic decision and they want a second bite at the apple, and they want to do it in a way that's completely biased and completely unfair. And so I would submit to you that I think you've heard enough under these circumstances not to go any further. That were you to go further, that you would have to consider what type of procedures you would be following. And that those procedures would potentially violate Ms. McIntyre's due process rights and this board to further litigation. And then further, it does establish a precedent that we don't want to go there. I'm not here to argue the enforceability of the NRA. Frankly, I disagree with Mr. Weintraub. I think that the impasse procedures that have been put into place, the impasse ordinance legitimates the MOU. Because what the law said is, absent statutory authority, the government has no right to delegate to collective bargaining. But I'm not here, and I don't think we're here to argue the legitimacy of collective bargaining. I hope not. But these parties have lived and died by the rules. And why Ms. McIntyre is being singled out, leaves us to wonder why she is being singled out. We recently had 2 meter readers who were reinstated as a result of an arbitration award. Did the division agree with it? No. They said that they had falsified documents. I mean, that's a bad thing too. So, but the point is, the division has to prove that they had just cause. And they didn't. And they lost. And that's where it should end, and the division should be required to put Ms. McIntyre back. She's been out of work since August of 2010. You heard what I read, that the parties are supposed to expeditiously hear these matters so that we don't have this type of situation. And here she is, the injustice that's been done has been done to her, not the Marquezes. Again, we don't want to get into the merits of it, but the injustice has been done to her. I would ask you to enforce the arbitration. So do you have any questions of me?
Questions?
If I may, Commissioner?
Yes, sir. Sure.
Frankly, it's difficult to debate an issue like this when I find that I'm in agreement with what much of Ms. Godwin says. I think she gave a perfect argument that the arbitration that we lost with the 2 individuals, we took our lumps and we went home. Do we agree with it? Absolutely not. But we took our lumps and went home. This is a unique case. It transcends the significance of just that case. Ms. Godwin notes that in the past, arbitration awards were advisory to the board. Again, the language of the memorandum states specifically from 1970 through today that nothing in the grievance procedure, in the grievance and arbitration procedure, is intended to diminish the authority of the board. You had the authority, you still have the authority, and I think all of y'all agree with that, if you have the authority. Ms. Godwin was not present, I believe, when the reference to advisory arbitration was removed. I do have individuals here who were present at that time, Mr. McClure and Bill Crawford. And I will tell you that there was no, the removal of the word advisory was basically done as a personal favor to a union official and to get certain things out of his face, but both parties understood that arbitration awards were advisory to the board. That has never been raised as an issue by the union in negotiations in those days. It was never raised. Everyone knew that the board had this authority and could choose to approve or reject an arbitrator's award. The interesting argument that Ms. Godwin makes about the workout class decision, Mr. Crawford, if he were to testify, would tell you that was not the union's position at the time. That is a convenient argument now, but it was not the position at the time. Now, with regard to grievance due process rights, she does have due process rights. I know that one of the things that I certainly would have no objection to, first, we don't want 50 witnesses coming in who were already testified saying the same things. Ms. McIntyre indeed has testified. The Marquezes, Ms. Marquez and her daughter, have not testified. However, all we're asking the board to consider is what the Marquezes have to say, because they directly contradict the sworn statements of grievance in that arbitration hearing for which we have a record. I do agree that Ms. McIntyre, after she hears the Marquezes, should have the opportunity to respond to that. There's never been a question of that in my mind. I don't want to hear a lot of witnesses testify, and I don't think Ms. McIntyre should start over and testify like on direct, going over all the facts. But if she wants to respond to something new that the Marquezes are raising, I think she should have that opportunity. I totally agree with that. Again, as we pointed out at the beginning, the grievance and arbitration procedure is the agreed upon procedure for resolving disputes. But that procedure includes the fact that the board has the authority to reject and approve. That is specifically part of the procedure. At the end of the day, we want the opportunity to bring Ms. Marquez and her daughter before you so that you can hear what we heard. Ms. Marquez told me, I'm not stupid, I know what she did.
I would object to that.
It's hearsay. The board's not going to consider that for its merit, but that's what she told me. And we're simply asking, because of the transcendent significance of this case, that y'all give management the opportunity to present Ms. Marquez and her daughter to testify about what happened to them. Thank you.
Any additional questions or positions? I'd like to share your respective opinions at this point, as we ultimately call for a vote on whether we hear this or not. Ladies first.
Well, I think we all understand that as commissioners, we have a responsibility to act in the best interest of the utility and the customers. I think that management and the union established a process for grievance resolution at the arbitration level, and it appears based on the information that's been presented today that the arbitration process was followed. You all know I'm a big person for policies and procedures because you may not like the outcome, but if we agree on the procedures, you'll at least be able to say that a fair process was provided, and it appears to me that a fair process was made available here. It appears that a qualified arbitrator was selected to review the matters. Both parties had an opportunity to present whatever they deemed to be appropriate evidence. It seems to be without any restriction as to what management is saying to us today. It considers to be major evidence. So, you know, I've not seen anything presented today to make me feel that we should be reviewing information that has been reviewed by a qualified arbitration professional, and the fact that management had an opportunity to present what it now has, in hindsight, determined to not have been a good decision about presenting additional evidence. It wants to now bring that before us, and I don't think that that's an appropriate support of the process that was agreed upon on the front end. So I think it would be in the best interest of the utility and the customers for us to uphold the arbitrator's decision. I think the fact that there was an interim ruling by the arbitrator to not admit the DVD, which appears to have been a major piece of evidence, meant that management had an opportunity to present witnesses and it chose not to. So I think we would be opening ourselves up to a long, arduous process that would not necessarily provide any better resolution than what we've already seen in the arbitrator's ruling.
So
Well, I agree with what you're saying. The only thing I think I would add would be that it is an issue of trust. But I think the issue of trust that I would speak of would be the fact that this organization, this board, and this management entered into a memorandum of understanding with our employees. Our employees, they don't read the fine print, okay? They understand this is the process. And we've got a certain amount of trust that we've got to have with those employees. I don't think they would appreciate it. I know from my perspective, I've often said that I don't want to do business with somebody I have to read the fine print with. So that matter of trust is very, very important to me. And it's important to me because of my personal feelings, but also for my responsibility as a commissioner. Because those employees are in the field every day with our citizens. And we have to feel confident that they are doing everything they can, and they risk their lives sometimes, and I'm not going to go in that direction, but they do some things that are very difficult. We have to be confident that they feel that we have their back. And so I feel that it is a matter of trust, and I don't think they read the fine print, and I think they think this is the process that they're supposed to go through. And they went through this process, and it was resolved. And I am not inclined, as Commissioner Evans is inclined either, to overturn that process or that decision. And by the same token, I may agree with management in the sense that I don't know if I want to bring Mrs. Marchese up here to go through that as well. So I think management might have made a fine decision in the decision not to have Mrs. Marchese testify. I don't see why we would even make it more of an unpleasant situation, testifying in an arbitration hearing versus testifying with possible cameras and reporters and so forth around the procedure. But more important to me is the issue of trust. We have that commitment we made with our employees, and I think we've got to stick with it. And therefore, I think I'm going to urge to uphold the decision of our arbitrators.
From my perspective, the thing that keeps playing over in my mind is how many opportunities do we provide for one side or the other to get a do-over, basically. Today or tomorrow or, going forward. And that creates, I think, a mistrust in the process, sort of to the point that Commissioner Masson has made, that if the arbitrator's rulings mean nothing virtually, and they can just be arbitrarily brought to the board and overturned by the board or heard by the board, then I think we get into an area that doesn't allow you to have confidence in the memorandum of understanding. I guess that's the point that you're making, Commissioner Masson. I do think, though, that there seems to be a lot of customary practice that's going on, and my advice would just be to let's get out of the business of customary practice and follow what's written and what's agreed to. The other thing is, as it relates to public trust, I think based on what we've at least heard is the accusation and the opinion of management, that the best thing we can do to address issues of public trust would be to make sure that there are policies and measures and safeguards in place to make sure that any question of employee impropriety is one, discouraged, and two, that there are checks and balances in place that alleviate that potentiality. The other thing I think is that I would ask that going forward that the board either adopt a policy or practice that arbitrators' rulings and findings of such be brought to the board for reporting and clear understanding of the merits of either side, so that we're not abdicating our responsibility or authority, as Commissioner Evans had mentioned. And finally, understanding the sensitivity related to customers and them being incorporated into this process. It was sort of said that we've decided that we will be calling witnesses, and I think that is a bit bold and cavalier to just toss that out there. I think that in calling a customer as a witness, you allow that customer to make that decision ultimately as to whether they want to participate and be subjected to whatever the good, the bad, and the ugly of that process if they feel they have been aggrieved in some way, shape, or form. And so, my opinion at this point, based on what I've heard today, is that although we do have the authority, although we do have the power to hear the matter, ultimately it's our decision as to whether we want to hear it or not. And in this instance, I think that there was a clear decision made by management to go in a particular direction, and the outcome did not come out in favor of that particular strategy, but that does not necessarily merit an opportunity to rehear and readdress the entire case. And again, I emphasize that as it relates to public trust and our desire to make sure that the customer is protected, that we ensure that there are measures in place to do that on a daily basis. So is there a motion as it relates to this matter?
Mr. Chairman, I move in the best interest of the utility and its customers, and to maintain the public trust that we have with our customers and all of our stakeholders. I move that we deny management's appeal to the Board of Commissioners and uphold the decision of the arbitrator in the Belinda McIntyre case.
Is there a second?
Second.
It's been moved, properly seconded. Will you call a roll on item number 13?
Item 13 is a motion to deny management's appeal to reconsider the arbitrator's decision and uphold the arbitrator's decision in the matter of Belinda McIntyre grievance. Chairman Brittenell and Vice Chair Wishing are recusing themselves. Commissioner Cobbin sitting as acting chair. Commissioner Evans?
Aye.
Commissioner Hassan? Aye. Commissioner Collins?
Aye.
Ayes have it, motion carries.
Seems like our chair has departed and vice chair. Oh, there he is. I got you and Commissioner Evans confused. Is there any further business to come before the Board of Commissioners? If not, we're adjourned. Thank you very much.